I had in mind to talk about, and it has to do with fixing credit report errors. Now, we just did a series of, it's probably like 10 or 11 hours worth of stuff on fixing credit report errors. So I'm not going to try and compress that, and cover everything. But just for, maybe 15, 20 minutes, just talk to you about some mistakes I see people make, whether they're fixing their own credit reports, whether doing credit repair. And I think if you'll avoid these mistakes, it'll make you much more effective and remove some frustration. So I'll tell you this. I had court one time in Mobile, Alabama, which is down on the coast. And so at the time I lived in Huntsville, Alabama, which is about 6 hours north. And so I'm driving, and I think I had to get some gas or go to a rest area, something like that. So, I'm kind of tired because I'd driven down to Mobile, argued a bunch of stuff in court. Now I'm driving back. I'm, thinking about stuff, and get back on the road. And then I start seeing signs for Mobile is coming up. I'm thinking, no, that's not a good sign. I'm supposed to be heading away from Mobile. Turned out when I got back on the interstate, I went south instead of north. Okay. Now, if you're going the wrong direction, you can step on the accelerator and it's not going to get you to where you want to go. You can say, well, I'm the greatest driver in the world. But if you're heading the wrong direction, we're just not going to get there. So I want to talk to you about a couple of these mistakes. And the idea is so that you'll be headed in the right direction and you won't have a frustrating experience. So first mistake is, and this is actually not a mistake if you just read the statute, but the way judges interpret it, this is a mistake. And that is not understanding the difference between accuracy, completeness, and verification. So the way we teach people to do disputes when you're looking at your credit report is you find a piece of data. So just imagine this represents a piece of data. It could be my name, could be whether I was late in May 2019 on my Capital One card, whatever it is. This is a piece of data on my credit reports. And we say, look at this piece of data and say, is it correct or is it incorrect? Is it complete or is it incomplete? And here's what a lot of people do is they'll say to me, hey, John, I want to get rid of this Capital One account on my credit report. I go, okay, is it your account? Now, John, it's never been verified to be my account. I go, okay, maybe I wasn't clear. Is this your account? John, it's never been verified. What are you talking about? Either it is your account or it's not. Well, John, if it hasn't been verified with the original contract with the blue ink signature, then I stand on my statement that it's not been verified to be my account. I'm like, that's not how this works. Okay. A judge is going to say, hey, John, did you have a Capital One card in your wallet? Isn't that their thing? Like, what's in your wallet? Yeah. Did you have a Capital One card? Well, Your Honor's never been verified to be my account. What that tells the judge and the lawyers representing the credit bureaus is I'm an idiot. I don't know what I'm talking about. Okay. Because the courts have consistently, maybe wrong, but it doesn't matter because this is what they do. They say it's not enough to just say to the bureau, you must verify this. They're saying you must tell the bureaus what's wrong with every piece of data. Okay. This is inaccurate. It's incomplete. Here's why. And then the bureaus have an obligation. So if you start with the assumption, all I have to do is send out a letter to the credit bureaus and say, here are these 17 negative accounts, please verify them. That doesn't put really an obligation on them. Now, can it work? Can you get some of those deleted? Absolutely. I mean, we could send it on pink paper with a green crayon, Crayola, and we could get stuff deleted. That doesn't mean it's deleted because we sent it on pink paper with a green crayon. So anything can work, but if you want to send letters so that either stuff gets fixed, deleted, or you can sue, then you have to understand this concept of its completeness, accuracy, and the verification as a practical matter just doesn't come into it. Okay. So all these letters where we send out and say, please verify all the details of this account. I can't sue on that. Okay. Now, if it's identity theft or a mixed file, or there are some exceptions where we can say, hey, I need you to go verify this. But as a practical matter, we bear the burden of showing this is inaccurate or this is incomplete. And so let me see, Rodney says, I had a repo removed from my TransUnion report, but I'm still waiting on the other two bureaus to acknowledge they've deleted it. Should I sue the furnisher when I get all three of them to delete it? And then do you have somebody in Arkansas? Well, so again, I would say on that, Rodney, let's say this is the repossession, and every piece of data on that repossession, we have to know, is it accurate? If it's accurate and it's complete, then there would be nothing to sue for. Okay. Now, if the bureaus delete it, they always have that option to delete it. If they keep it, then the only way we can sue the bureaus is if we have identified, and we'll get to this in a moment, each piece of data that is wrong or incomplete. And if they all the bureaus delete it, then as far as suing the furnisher, whether it's a debt buyer, whether it's a car loan company, we could only sue them if they did a lousy investigation. And frankly, if it gets deleted, you're not really suing them under the FCRA anyway. So we just have to really grab hold of this concept that we have to find something that's inaccurate or incomplete. Let me give you a parallel. So probably 15 years ago, we started teaching this concept in debt buyer lawsuits. So when you're sued by a debt buyer like Midland, LVMV portfolio, and maybe somebody else had done it, I had not seen it, okay? And I'm not saying nobody else has come up with this, but we started teaching this publicly about 15 years ago. And that is the concept that there's a big, big difference between you owing a debt and a debt buyer owning the debt. So when we get sued by Midland, when I first started doing this, because I'd never walked into a small claims court in my life, okay? I do personal injury, truck wreck, railroad cases. And so I walk in and it's Midland Funding, let's say it's Midland Funding suing my client. And they say, well, how much do you want to pay? I'm like, I'm not going to pay anything. And they're like, okay, well, we're going to try it. They're like, Judge, John doesn't want to pay anything. And Judge looks at me and says, well, John, does your client owe the debt? I'm like, probably, but not to Midland. And Judge's like, what do you mean? I mean, Midland owns the debt. I'm like, that's what they have to prove. And the judge said, well, if you owe the debt, don't you owe it to Midland? I'm like, no, Midland has to prove it owns the debt. Just like Your Honor, I can't sue Your Honor for your mortgage payment unless I own the right to receive your mortgage payments. And then it kind of clicked and they go, okay, well, lawyer for Midland, do you have any proof you own it? Like, no, we don't. And so the point in sharing that with you is to say that one concept has helped, be successful with, thousands of debt buyer cases. Okay. And so I really want you to understand this concept with credit reports, that you've got to find the inaccuracy or the incompleteness. And we want to show that to the Bureau. Okay. So now let's talk about how do we do that? Well, put yourself in the shoes of the credit bureaus, okay? Equifax, Experian, TransUnion, Innovis, whoever it is. They get a dispute. Well, there's kind of two ways that they can figure this out. One is they look internally, so sort of within the four corners of the credit report they look at, or they look externally out to find the answer. So internally, here's what I mean. If my credit report says I was 30 days late in May and 90 days late in June, I have one I'm doing a dispute on today with this exact thing. Well, internally, you can look at that as a credit bureau and see that's not right. Now, it doesn't tell them, exactly what it should be, but they know there's no way I can be 30 days late and then the next month 90 days late. Maybe I was 60 days late here, but I can't be 30 and then 90. There's not enough days in it. Okay. Incomplete data. We can point out to TransUnion, hey, you're missing these 3 months worth of data. Okay. So we can do that internally. We can also say among the credit bureaus, because I send one letter to all three bureaus. Say, look, Equifax, you say this, but TransUnion, you say that. Experian, you say this. Y'all get together and figure it out. Okay. But then there's also external. All right. And so if Capital One says I'm 30 days late in May 2018, and I say, no, I paid that on time. Well, how does a credit bureau know that? I should give them my bank statement, highlight for them. See right there, I made my payment. Okay. And that gives them something to go on. Okay. And it also puts a greater obligation on them and Capital One to fix this. Okay. So here's a very common type of case that we have. Actually, one we're mediating on Thursday is this, what exactly I'm going to describe to you. We get sued by a debt buyer. We beat the debt buyer. We then dispute that with the credit bureaus. And we say, here's the lawsuit. Here's the order. Or here's the case number. Or here's the court that you can look this up. In other words, we give the credit bureaus the information or the ability to go get the information so they can decide for themselves. Are we telling them the truth? Are we lying? Do we make up these documents? And so we have to keep that in mind. It's very easy for me with our processes and systems and some of the credit repair guys that are on here. I know it's the same for you guys, to look at a report and find those internal inconsistencies. Okay. But what we need our clients, so for the consumers that are watching this, you need to be able to tell us the external stuff. I don't know that your Blue Cross Blue Shield health insurance paid off that bill a year ago that a collector is now reporting. You have to tell me that. And then we want to go present that proof to the credit bureaus, or maybe we want to just sue the debt collector without disputing it. So the point is that either you or we can look internally on your credit reports and find the things, but the external, you have to go find that information. Here's my bank statement. Here's the where my mortgage was satisfied, and now they're coming back saying, oh, $100,000. Well, hey, let's show that satisfaction of mortgage. So hopefully that makes sense. We want to, as we look at each piece of data, we want to say, all right, can the credit bureau figure this out without looking at any other documents? Well, let's tell them. And if they need other documents or other information, can we give that to them, or can we point them in the right direction? And when we do that, it puts a real heavy burden on these bureaus when they want to not properly dispute. Now, if they want to do real disputes, it's not a heavy burden at all. But when they outsource everything and they don't want to spend any money on doing investigations, now when you start pointing out all these errors, it really puts them in a bad spot because they're unwilling to do what's necessary to properly evaluate your disputes. And I'll just say this, it is much more common now than 20 years ago when I started suing the credit bureaus for the bureaus to just not respond to a certified mail dispute. I mean, you mail it, you get the green card, you go on USPS website, they signed for it, and they just won't respond. And that's where we come back to the first mistake of, just sort of saying, well, you guys have to verify everything. And if you can't verify it, delete it. Well, if they don't respond to that, we're not getting anywhere in court. But when we identify each piece of data on each account that is inaccurate or incomplete, and then the credit bureau doesn't even respond, that's a great case against them. Now, if they respond and they delete or fix, there's no case against them. But if they refuse to do that, then we have a case. So if they respond and they keep the incomplete, inaccurate information, we sue them. If they don't respond at all, we sue them. And so you're just really putting yourself in a great position when you do the disputes the right way up front to say, here's what's wrong, here's what's missing, fix it or delete it. And I always tell my clients, they have three choices. They can fix it. And so like that example of it says 30 days late, then 90 days late. Maybe fixing it is the 30s really is 60. Well, hey, we point out an error. They have the right to fix it. So that's okay. So they can fix it or they can delete it. Or option number 3 is they say, please sue us. So we'll delete it. We want to pay you money. Hey, if that's the choice they choose, then who are we to keep them from exercising option number 3? So And I always tell my clients, the money from the credit bureau spends just fine. Their checks don't bounce. So let me check out our comments here. Let's see. Chi says, had an account that was written off and the creditor is charging my debit. So I'm assuming your debit card. So if it's written off, that doesn't mean the debt's not owed. It just means they're saying we don't expect to collect it. So if they're charging your account, and pulling money out of your bank account, they have to have permission to do that. So I just want to know a little bit more about what's going on there. Let me mention something else, and I probably should have started with this, but I really wanted you to have the foundation for, understanding it's complete, accurate, and not this just verify everything. And then how do we, analyze each piece of data to find the incompleteness and inaccuracy? But to do that, you have to have the correct data. So, imagine this, and I'll do both presidents. So, we can offend everybody here and not just one side. But imagine that we were critical of Trump, President Trump, because we saw a quote from him where he said, the Russians were behind everything, and I don't make any decision without Putin telling me what to do. We go, see, look at this. And so, we grill him on a news program, or we impeach him for that. And it turns out it's fake. That was never true. He never said that. We're like, but it really is a great quote, and I really want to hammer him on that. Well, you can't do it because it's not accurate. Now, again, so we offend everybody, President Biden, there's a quote from him where he says, I have no idea what's going on. I just do whatever Nancy Pelosi tells me because I don't understand anything anymore in the world. And we're like, well, let's get rid of him. And then it's proven he never said that. And we're like, but that fits my narrative for him to say that. Well, see, we have to have the correct data. And if we're using anything other than the real credit reports, so Equifax, Experian, TransUnion, we have to get the data directly from them to know if it's accurate or not. So if we're using Smart Credit, Identity IQ, those have their advantages and they can be useful, but it's not the real data. And I know this from, unfortunately, personal experience, where we've sued and we said, look, you had this incorrect data on there. And the Bureau goes, no, we didn't. I'm like, yeah, here it is. And they're like, that's not our report. This one happened to be a mortgage tri-merge report. But see, even that is not the real data. And so we may be disputing something that's just not actually present on our reports. And we don't want to go into court and the Bureau say, we never said that you were late in May. Look, here are your disclosures. They never show you were late. And we're like, but Smart Credit said that you told me I was late. So we can use Smart Credit, Credit Karma, all that stuff as a tool, but never confuse that with the real data. The real data is directly from each bureau. So here's what I mean by that. Sometimes I'll say to people, look, give me your real credit reports. And they give them to me and I'm looking at them. I'm like, this doesn't look like TransUnion. And then I realized what they did is they have like a 3-in-1 product with Experian, where Experian says, well, this is what your TransUnion report says. Well, guess what? That's not directly from TransUnion. It's not the same. If we want to know what TransUnion says, go to TransUnion. If we want to know what Equifax says, go to Equifax. We want to know what Experian says, go to Experian. Same thing with SageStream and Innovis and all these other, there's hundreds of credit bureaus. So the way we do that with the big three is we go through annualcreditreport.com. Okay, now you can also go to myequifax.com, Experian.com. To my knowledge, maybe Cedric or Warren know something that I've missed. I don't know a way to get your free TransUnion report outside of annualcreditreport.com. I mean, you can mail for it, get it through the mail, but I'm not aware of sort of the equivalent of Experian.com. You go there and, you get your free report. And the reason they do that is they want to market to you. Okay. But the easiest thing, annualcreditreport.com, go once per week for free, save it to PDF. Those are your real reports. And that's what we need ultimately if we're filing a lawsuit. So let me check out if we got any questions here. Let's see. David said, made the mistake of not getting signature confirmation a few times. Then you can't prove it. Learn the right way. Yeah, now I can prove 2 times they didn't do it right. Yeah, you want to get that signature confirmation. And look, during the height of COVID, and who knows what's happening with, this Delta thing. But, sometimes you wouldn't get like actually Equifax signing it. It would like literally say COVID-19. It's not the best, but you just sort of do what you can, but it's definitely worth paying the money to get that signature. You can get an electronic signature, or you can get the green card, whatever you want, but you just want to prove that it was delivered to Equifax, Experian, TransUnion. And, like I said, I used to see the bureaus not respond if it was done by regular mail. So that's kind of easy because they can just lie and say they never got it. But with certified mail, it was really, really unusual for the bureaus not to respond. But I think almost every Fair Credit Reporting Act case I have filed this year, I have at least one bureau that never responded, just flat out never responded. And, we sue them because not doing an investigation is the same as doing a lousy investigation. That was one time they argued that. They said, well, you can't sue us for doing a lousy investigation because we did nothing. I'm like, do you think that's legitimate? You can just like refuse to investigate until the end of eternity and you can never get sued? And so you have to understand they make these absurd arguments. So it's worth the extra money to get the proof there. So thank you for that comment, David. And she said, what do I do when a creditor deleted an account after verification request and after a few months wrote me providing some of the information? So, if you have a creditor that has been deleted from your account, you have to know, did they sort of delete themselves or was it in response to an investigation? So in other words, did Equifax delete them or was it just Capital One said, we're no longer going to report? That can make a difference, what's called reinsertion. When something's been deleted, then it comes back on. They need to tell you within 5 business days that they've done this, okay? But if it's just the furnisher deleting, then they would not have to tell you if they decide to put it back on. Let's see, Cedric said you spoke on a court case about Credit Karma. Yeah, thank you for reminding me, Cedric. So there was a decision where this was a court case somebody filed. I can't remember if it was an FDCPA or FCRA case, but the crux of the case came down to what exactly was being reported. And the consumer and the consumer lawyer are like, look, here's my Credit Karma report. And the judge is like, that's not the same thing as TransUnion or Equifax. That's Credit Karma. It's what Credit Karma thinks or summarizes or says that Equifax and TransUnion are saying. And what is it? Credit Sesame is the Experian version. So, if we go to Smart Credit, they are saying, hey, we are pulling from TransUnion and TransUnion is telling us what Equifax and Experian say. And then Smart Credit is sort of assembling it to make it easy to read. And look, it's incredibly easy to read a Smart Credit report. Same thing with Identity IQ. They sort of have the 3, for each account, the 3 bureaus sort of lined up. It's very easy to look at. It's nice looking, but you're not getting necessarily the accurate data and it's missing a bunch of stuff. And so let me just mention this. A lot of you will be familiar with this, particularly those of you that are in the credit repair world. But the trended data is very, very important. So that's typically, although sometimes it's more than this, typically 24 months of data. And instead of just, when you look at sort of the payment grid, instead of just saying okay or current or 30 or 60 or 90, it gives you more details. So for each month, it has what's your balance, what's your credit limit, schedule payment, the amount paid, things of that nature. And here's why it's important from a credit scoring standpoint, but also from finding errors. Remember, I talked about we look at each piece of data, okay? So the reason it's important is, let's take Cedric, for example. Say Cedric and I are identical in every way, and we both have a Discover Card account, and we both have a $10,000 credit limit, and we both owe $5,000 today. was today? July 30th, I think. Well, we would then be viewed the same, right? But what if we knew this? What if we knew 2 months ago Cedric owed $10,000 to Discover Card and I owed zero? And then a month ago he owed $7,500 and I owed $2,500. And now we both owe $5,000. Would you treat us the same? Well, if you were loaning us money, I think you'd say, well, it looks like Cedric was kind of up here and now his debt's going down. And John, it looked like your debt was here and now your debt's rising. So he would be much more attractive as a person to loan money to than I would, because he's trending in the right direction. I'm trending in the wrong direction. So that's sort of from a credit scoring, and certain of the scoring models account for this. But when we're looking to dispute stuff, if we just look at Credit Karma, we look at Smart Credit, we look at TransUnion's report that we buy from Experian, we're not going to get that trended data. Okay, we need to go directly to the source and get Equifax, get Experian, get TransUnion, because every piece of data in there is something that could be inaccurate or incomplete. So I'm trying to think if I ever have a dispute letter that doesn't point out, hey guys, you're missing, for example, the balance on May 2020. Okay. Or, we see the balance going down, but there's nothing mentioned about payments. I mean, I don't ever see credit reports that have, let's say, my typical client has 5 to 10 inaccurate items, or negative items, I should say. I don't know that I've ever seen a credit report with that many negative items where it's not missing data. In other words, it's always missing data. Okay. And so when you can have that trended data, it's just more data, more opportunities for you to point out errors. But if you're using Smart Credit or Credit Karma, you're just not getting that. So it's kind of like you're going into the game without all of the tools. Hey, we're going to go to a Super Bowl and not throw any forward passes. You can still be successful, but why limit yourself like that? So that's my point, is just pull those real credit reports and use those. Let's see. Cedric says, if the credit bureau does not respond after you sent certified mail and they fail to investigate, how many days do you wait before you seek legal counsel? So great question, Cedric. Here's what I do is, you've got to allow for mailing, right? So like we know they signed for it on July 1st and they have 30 days to investigate. Well, July 31st, I would not say, let's, get a lawyer and sue on this. Because they could have completed their investigation on July 31st and then they mail it to you. Maybe that takes 7 days, 10 days to get to you. So what I tend to look at is more of like 45 days or 6 weeks, 42 days. And I always pull a new report, because here's what I don't want to happen. I've never had this happen, but part of what we do as lawyers is anticipate the problem. I don't want to say, okay, here's when they got my dispute and here's when their deadline ended. So now I'm suing them. And then they produce where they say, well, actually we did, do the results investigation and we mailed them to you. Maybe you didn't get them, John. Like, okay, well, that's possible. So what I do is we do the dispute and then the time goes by. And then before we sue, I always want to pull the credit reports again. And not to beat a dead horse, but the real credit reports. Okay. So sometimes I talk about this being the before, during, and after. So the before is what led you to do the disputes. It might be a Credit Karma. It might be a Smart Credit. That's fine. Here's what led me to the dispute. All right. Then the disputes are the during. Okay. We do the disputes. Well, let me see those disputes. Were we specific? Did we point out the errors? And then the after is the results of investigation, which you should get from the credit bureaus. But as Cedric pointed out, sometimes they don't send those to you. But what if when we pull the credit reports, everything that we disputed has been corrected or deleted? Well, even though they didn't send me results of investigation, if I can see everything has been fixed, then I'm not going to sue on that. And if they did not fix it, though, I want to lock that in. And so I can, like, here's my credit report, or consumer disclosure, if we want to be technical. here's my credit report, okay, on this day. So if I sue Equifax and they go, oh, well, actually, we did correct all this. I'm like, well, you didn't correct it before I sued you, okay? And, even, and that's not actually the sole test. I mean, if they don't fix it in their time period, and these are legitimate disputes, we can sue them, even if they fix it right before we sue them. But I like to pull a credit report before we sue so we can show the errors are still there. Then we sue, and then they'll fix it after we sue, okay? And we get to point out the only reason they did that is because we sued them, okay? They don't care about your dispute, but they do care about being sued and having to pay money, okay? So Cedric says moving to Alabama. Well, I'll say this, Cedric, we do handle cases in other places, usually with co-counsel. So, if you have something there in your neck of the woods, just let me know and happy to talk to you about it. And so Marche said, hey, Marche, good to see you. What if the account was never marked disputed during those 30 days? So if you have, so it's a great question. Let's talk about two different types of things. If it's a collection account and that collector knows that you've disputed it, they have to mark it as disputed under the FDCPA, Fair Debt Collection Practices Act. This is section 1692E8. So if the Bureau notifies the collector, hey, Marche is disputing this, and they don't mark it as disputed, then we would sue on that. Now, if it's not a collector, then if you've made what's called a meritorious dispute, okay, so with the FDCPA, you can just say, look, I dispute this. You don't have to give any reasons. But if it's not a debt collector, we need to give some reasons. And if it's a legitimate dispute, which go back to what I've been harping on all this time, like you take each piece of data, is it correct? Is it complete? If you're doing that type of dispute and they don't fix it and they don't mark it as disputed, now this would be at the end of the 30 days. So there's no requirement that like on day 2, they mark it as disputed. It's really by the time we get to the end of that investigation, if they marked it as disputed, then that would violate the law. So hopefully that helps you there. So we've talked about, understanding completeness and accuracy and doing disputes the right way. Obviously, you got to make sure that they get the dispute. So we've talked about certified mail. If you do it by an online dispute, just record your screen, okay? And I talked about this in our bigger training course. You can do Snagit, you can do ScreenFlow if you have a Mac, but you can also just do a Zoom. Just do a Zoom with yourself and go to Equifax.com, log in, do your dispute, Experian.com, do your dispute. And that way you're recording it. So when they argue, well, you never told us this in your online dispute, you're like, yeah, I got the video of it. Okay. So however you do the dispute, you want to be able to make sure that you can prove that you actually did the dispute and what you said. And then we'll talk here in a minute about just, okay, what happens after you do your dispute and they either fix it or don't fix it. So let me see. Marche says, if the collector is notified by one bureau, are they obligated to note the account dispute on all 3? Yeah, it's a great question. So let's use an example. You've got enhanced recovery on your credit report, and you only dispute it through TransUnion. And TransUnion sends you results of investigation back, says, we have contacted the furnisher, enhanced recovery, and they have verified to us the accuracy of the reporting. Well, that tells you they notified enhanced recovery, you dispute this. So then when enhanced recovery updates on any of the reporting, whether it's TransUnion, Equifax, Experian, they must mark that as disputed, or they would violate the FDCPA. Now, they'd also violate the FCRA. So that's hopefully that answers your question there. What happens if creditor does not report to credit agency? How do they verify one's account? Okay, so maybe help me understand that a little bit. Are you saying if there's just no reporting by like Bank of America, how would you verify that? Or are you talking about they don't tell the bureaus that the account is disputed? Just let me know about that. So let's talk about I tell you what, let's talk for a moment. I've got a little bit more time here. Let's talk about doing the disputes themselves. So how do you word the disputes? Well, there's nothing magical about it. Okay. But I'll share this story with you. When I would help my kids with their math, we'd sort of get frustrated because I'd say, "Hey, you're not showing your work." And if they got the wrong answer, I'm like, "If you'd showed your work, you would have seen you're coming to the wrong answer." And the response was, "Well, that would cause us to use another piece of paper." I'm like, "I'll buy you more paper. Like, show your work." And so sometimes I see this in the credit repair world, fixing your credit report world, where people say, don't use more than 1 page or 2 pages. Use 25 pages if you need it. I don't care how long it is. Use as much space as you need and put all the errors in there. So again, there's this idea, well, don't dispute more than 5 accounts, or don't have more than 3 areas of dispute on each account. That's just not correct. Okay. Now, part of there's a legitimate and an illegitimate reason for typically credit repair companies saying that. The illegitimate reason is they want to slow down and drag out the length of time so that you're paying them $100 a month. Okay. The somewhat legitimate reason is that there is an idea, and sometimes it's right, that the credit bureaus, if you dispute a dozen items, they may only pick out like 3 of those to actually investigate. And so if you're doing credit repair trying to get this stuff deleted, then you may want them to really focus in on, so you only do 3, 4, 5 at a time. From my standpoint, I'm wanting to give the credit bureaus all the errors and say, guys, it's totally up to you. Do whatever you want or don't want. If you don't want to investigate any of them, great. I'm going to sue you for all of these. Okay. If you only want to investigate 3, I've sent dispute letters where we're disputing 20 accounts and each account might have half a dozen errors on it. Well, if they choose to only investigate 3 of those, and let's say they fix all of them, well, great. You don't get sued for that, but you get sued for all the other stuff. Okay. And they go, well, it was kind of a long letter, John. It had a lot of accounts on there, a lot of errors. So what? There's no rule that says I have to only do 1 dispute per month per account. It's just so. My approach is we put it all out there to them. We make it super clear, super easy. Make your letter easy to read, easy to understand. If you're doing a bunch of different accounts, bold the accounts, describe the accounts. So here's a lot of times the way I'll say it is I'll say, look, this is my Capital One account. It's an individual credit card that was opened on March the 5th, 2019. Okay. Well, that's pretty easy for them to find. Okay. Now, the next one might be, now here's another Capital One account. This is a joint auto loan that was opened in 2014. Okay. I'll make it easy for them. So you just want to imagine the judge is reading your letter. Okay. Because you've sued. And that judge, she's looking at this saying, if she goes, I can't make heads or tails out of what you're saying in here. You're talking about admiralty law and no blue ink signature, and we went off the gold standard, and I don't know what this means. Okay, well then you're going to lose. But if your letter is such that she can read it and go, okay, yeah, I see that you point out to TransUnion, how can you be current in April and then 30 days late in May and 90 days late in June? That's a good question. Okay, TransUnion, how is that possible? And they go, well, we couldn't understand the letter. She's like, this is simple to understand. Okay. So we don't have to use technical things. We don't have to, make it super tiny print so we only take up 1 page. Just make it legible, make it easy to understand, because that's what the judge is going to look at. I can't tell you how many lawsuits are lost because even though the consumer was right, their dispute letter was terrible or is very confusing. It's like, I've got a credit card account on my credit report that is inaccurate. The payment history is all jacked up and I want you to fix that. And judge is like, Well, did you only have one credit card account? I mean, I guess if you only had one credit card account, maybe they could find it. You're like, well, no, I had 5, but they should have known which one I was talking about. Nope, you lose. Just make it easy. I've used this example before of, imagine if you have all the credit bureaus and you have Capital One and Midland Funding and Bank of America and Santander, all those guys. They're all sitting around a table. So they're in your kitchen, sitting around the table, and they're like, hey, we understand you have some problems with credit reporting. What is it? Well, you wouldn't be vague with them. You wouldn't be, well, now I'd like to dispute the account. They're like, what? You'd say, look, guys, the Capital One account, the credit card one that says I opened it March 2019 that has a $1,500 balance. That's the one I'm talking about. And you sort of see, they're all flipping through their page like, okay, we got that account. Now what's wrong with it? And you say, I want you to verify all information. They're like, we're sitting here at your table. Tell us what's wrong. Okay, so we'd say, look, Equifax, you say this, but TransUnion, you say that. Which one's right? Okay, or you're missing this data. Hey, Experian, why don't you have any data for the months of February and March 2019? Well, maybe Experian sort of turns their head to Capital One and says, yeah, guys, why aren't you sending us data for those months? Or maybe Capital One is looking at Experian saying, we sent you that data. Why aren't you reporting it? And that's when you sit back, you're eating popcorn, you're just sort of watching this thing. But just imagine you're there in person with them. You would just explain it to them. You would just use simple language. You wouldn't, use these big words. You just like, guys, why are we missing this data? How come you say that this is something I'm seeing more and more of? So it'll say my balance was 500, 450, 400, 350, 300, 250, 200, 150. But for amount paid, all those months, it says 0. Now, how is that possible? So we would just say to them, guys, how's my balance going down if I'm not making payments? Explain that to me. And then if they ignore you, a judge looking at this like, pretty reasonable question. Why are you showing that no payment was made? Okay. So just imagine you're sitting with them. Obviously, we don't do that in person, but we do that with our letter. Okay. So that's my suggestion for you. A couple of just final things before we wrap up. If you do these disputes and you get just nothing back at all, well, like I was saying to Cedric, pull the credit reports, give them 45 days after the dispute. And all right, they didn't do anything. First of all, you could always call them. Hey guys, did you get my dispute? Now we've had them lie about that. They say, nope, never got it. And we're like looking at the green card, like it's signed by you. They go, nope, we never got it. Now what happens when we get into litigation is they go, oh yeah, we got it, but then we lost your letter. So not our fault. We're like, yep, it's your fault. Okay. So you can call them. You can go on myequifax.com. Sometimes your dispute results will be there, even though you disputed it in writing. If you go under myequifax.com, it's totally free. There's sort of like a little dispute tab or folder, and sometimes you can find it. Occasionally with Experian, although I'm trying to think, it may have been a long time ago when I saw an Experian on there. But there's always a chance they got lost in the mail coming from the bureaus. So again, look at your reports. This is one reason why we use spreadsheets. So we've got, here's my Equifax report, TransUnion, Experian. Now here are the results of investigation. And here are my new reports. And that way I can kind of look and see, okay, the stuff I challenged, did it get fixed? Because even if they don't send me a letter, but they fix it, I'm not going to sue them for that. Okay. But you want to know if they fixed it or not. And then, if you get those results of investigation, or if you don't get them, again, pull those credit reports and just look at it. And you may decide everything's great. They did what they're supposed to do. Wonderful. You were successful. Or they deleted it. Great. Successful. Or you say, you know what? I want to dispute it again. Maybe I don't want to, but I need to. I'll give you an example. There's false information. You challenge it. They fix it. And then they put false information on the next month. Well, technically you didn't dispute the next month because it wasn't even the next month. Like, so let's say that my paid off Nation Star mortgage shows that I owe $50,000 this month, and I paid it off last year. And they say I'm 120 days late this month, so I dispute it, and they delete that, and then they show me for September as owing $50,000 being 120 days late. Well, technically I didn't dispute September because I did the dispute in July. I didn't know about September. Well, there's a point where that becomes silly. Okay. They can't just keep putting false information. But the point is, there might be a situation where you go, well, I need to dispute this again. Okay. Do another dispute. Sometimes people dispute just to sort of give them more rope. It's like, hey, if I dispute it one time, I could sue, but I'll give you another chance and you don't fix it. I'll give you another chance. And now that case may be worth multiples of what it's worth if we only do one dispute. Okay. So we can give them more chances. I mean, I have some where we've disputed probably 7 times. Okay. And it's just like, I don't know, let's see if they give them another chance to fix it. Okay. And so it's kind of hard to argue, well, it was just a mistake, 8 times in a row. But you also may want to just go ahead and sue. And so if you don't have a lawyer, get with a lawyer who does this type of work. The best situation is in your state, okay? Because there are some state issues, where can we file these and that sort of stuff. But if you don't know somebody in your state, feel free to reach out to me if you're not in Alabama. I mean, if you're in Alabama, I'd love for you to call me. But if you're not in Alabama, reach out to me and say, hey, here's the state I'm in. And I'll let you know either we can help you or we may know a lawyer there that would be a good lawyer for you to talk to. And then you just lay this out. And if you've done the disputes the way that I'm suggesting, where you say, we've identified every error, we can prove it was received by the Bureau, here are the results, or there aren't results of investigation, and here are the new credit reports. And look, you can see, the 5 things I challenged on my Bank of America mortgage on the new credit report, pulled 45 days after they received my dispute, they still have 4 of those errors on there. They didn't fix them. Well, now that's helpful to know that we can sue. So I'm looking at the clock here. I actually have a call at the top of the hour. Looks like we've got about 10 more minutes. So if anybody has any questions, I'm happy to answer those. Or if you have suggestions for future weekly webinars, and I don't mind doing these where there might be 2, 3, 4, 5-part series, or we can just sort of do one off, or just do open Q&A. I'm open to whatever is good for you guys. I'm doing this to hopefully help you and to be of value to you. So just let me know. Let's see here. We've got, can you give sample dispute letters for some scenarios? And then Eric asked, any info on third-party mailers? So yeah, those are both good. So maybe what we could do on those scenarios is I can certainly give you some scenarios and then sort of how I would do the dispute letters. But also you guys are welcome to, if you want to send me stuff, I would just say kind of redact it so I can use it, black out the account number or something. And I'm happy to look at those and say, okay, well, here's how I would type the dispute letter. If that would be helpful, I'm happy to do that. And then on the third-party mailers, so that's a very interesting thing. So let's make sure we're all on the same page, at least what I think Eric is talking about here. So the 11th Circuit said that when a debt collector, like Portfolio Recovery, for example, when they mail you a letter, they're not actually mailing you the letter. They transmit the data to a mailing vendor or third-party mailer, and they print out your letters and they send them to you. Well, the 11th Circuit said that is what's called a third-party disclosure. So if Warren is collecting a debt on me and he calls me or my spouse, that's not a third-party disclosure. But if he calls my neighbor, that is. He calls my kids, that's a third-party disclosure. So they've made a third-party disclosure by sending it to a mailing vendor. And typically these are out of, I think it's Concord, California, if I remember right. And you'll just see it, like all these collectors have the same thing, and it'll be like, Unit 101 or Box 202 or something. And So right now, only the 11th Circuit has ruled on that. That's Alabama, Georgia, Florida. Of course, the industry is having a complete come apart about this. Like this will destroy our industry and blah, blah, blah. But, the 11th Circuit said basically take it up with Congress. Or here's an idea, bring all that outsourcing in-house, and then you won't violate the law. Our job is not to write the law, it's to merely interpret what's already been written. So, interestingly, if I remember right, the lead author in that decision is a Trump appointee. So this would be a very conservative person. And this is a conservative approach to it, to say, look, we don't make a judgment about whether Congress should have written this or should not have put this into the law. That's not our role. Our role is to say, here's what the law says. We don't write the law. So it's what's called the sort of strict construction version, or a conservative approach to reading the law. So those are very interesting cases. If you're outside of Alabama, Georgia, Florida, we don't know how the courts will interpret this, but certainly if you're in Alabama, Georgia, Florida, those are cases that can be brought, and there's no guarantee that they'll work. The 11th Circuit might change their mind, but that's pretty rare that happens. So I like those cases, and we definitely bring those. Let's see, Roger asked about the arbitration webinar. If you signed up for it, Roger, you should have got an email with the replay link. If you didn't, just reach out to me and I'll get you that link. And that's part of why I wanted to, instead of having all these different webinars, it's starting to get, confusing. I wanted to just have like one sign up, just our weekly webinar. And that way, whether you attend or don't attend, you'll get the replay link. But definitely let me know if you don't get that, Roger, and I will get that link to you. And I think we had a few handouts. I'll get those to you as well. And let's see. So Warren asked a good question here. What kinds of damages can you get from incomplete payment history suit against CRA? So I'll just tell you the way I do it is I look at FCRA cases that you have sort of the minimum case. This is, some people call these technical cases. It's just there's a violation. You point out the violation. They did not, or you point out the inaccuracy, the incompleteness. They don't fix it. That's different than a case where, this cost me a mortgage and it's blatant errors, and I might have, hundreds of thousands of dollars in damages. So some of our FCRA cases, we go in, when we file the case, we know that they will pay us six figures in this case. Okay. Something where it's just an incomplete history, that's the only thing, it's that missing data. We point out the data is missing. They don't fix it. They don't delete the account. To me, the bare minimum a credit bureau should pay, or a furnisher for that matter, would be $10,000. Okay. It can get a little confusing, and I don't want to get super bogged down in this, but we don't settle individually with defendants. So if I sue, like I've got this mediation coming up next week with 5 defendants, so 3 bureaus and 2 furnishers, we will not take a settlement just with TransUnion. It's all or nothing. So typically it's called a global settlement. So we'll sort of price things in our mind and say, well, we know what each company is on the hook for, and then here's what they have to pay globally. Now, I don't care who pays it, right? If TransUnion pays the whole check, what do I care? But just in terms of damages, and maybe this is not exactly answering your question, Warren. I'm talking about a settlement value. I'm talking about they come in quickly. We're not doing discovery. I think any defendant in an FCRA case, minimum $10,000. Okay. And certainly a lot of these, they're paying 6 figures. Okay. But that's what I would look at in terms of damages. Now, you may not have scoring damages, or it may be sort of expensive to prove. So generally what we're looking at is emotional distress. I've got this incomplete thing. I notified Experian. They ignored me. Okay. That's very upsetting to me. And every state, every sort of federal court has a little bit different interpretation of how you prove that. But almost every place says you can get those damages if you do a good job of proving emotional distress damages. And then we also look at it from a punitive damage standpoint. Hey, I told you it's obvious and you just completely ignored me. You should be punished for that with punitive damages. So hopefully that helps. Let's see, Marie says, can the credit bureau reply to, let's see, Experian not replying to dispute electronically? Is that legal? So I'll say this. If you dispute online, you typically agree that they'll give you the results of investigation online. I don't know that they're required to do that. They could just mail it to you. I mean, that's sort of what the statute contemplates, is that they'll mail it to you. But they could send it to you electronically. Now, I see what you're saying. Experian is now replying to dispute electronically. So if you send it by letter and they reply electronically, if you can get all the data, okay, from the results of investigation, then I would say that's fine as long as they're giving you all the data. Now, if they're not giving you the data, or they're saying, well, you've only got, 4 days to look at it, and then we're like completely wiping it out and you'll never know, that's not fair. So I would try to get it whatever way that they offer it to you, but also remember, keep pulling, for example, Experian's credit report on you every 7 days for free. Okay. And then in a sense, it doesn't matter what the results of investigation say. You can look at the credit reports, week after week and see, did they fix it or did they not fix it? And Warren says his emotions are hurt bad. So, we'll be the judge of that, Warren, whether you've really been emotionally upset or not. But no, that's fine. Get with me and we'll be glad to talk about that. So I do have a call here, I think in like 50 seconds. So thank you everybody for being here. Nothing like a Friday to spend time talking about credit reports. So appreciate you guys being here. And just remember, I'll have to send out an email about when we're doing it next week. And I don't know the topic yet. Y'all can always make suggestions, and I am happy to, put on whatever will be helpful to you. So you guys have a good one, and we'll see you next week. Okay, bye-bye.